Anyway,
Yes.
Erin Patterson case.
Yes.
What's your thought?
Don't eat mushrooms. No. No, look,
Have you been following it, or just
I've been-
hearing bits and
I've been following it a little bit, especially in the beginning. Not so much towards the middle, but
Why the beginning?
Huh?
No, why just the beginning?
I think because
I thought the beginning was actually quite dry.
well, as a criminal lawyer, you get to figure out early on. You get a hunch as to whether someone's done it or not. Well, in this case, I had a hunch that she had done it, and I suppose at that stage I had put on my prosecutor's hat because things just didn't add up, and it's funny that if you're going to invite a whole group of people to lunch and you're going to poison them with mushrooms, but you're the one that survives with no toxins in your body.
Bit
Not-
suspicious, right?
Yeah, a bit suspicious. So one kind of thinks, well, why did you go through that? And I suppose a lot of the public might have thought, well, she must be innocent because no one could be that stupid to go and do that. You know? But
Oh, question.
yes,
You know how like the prosecution says they could not find a motive?
yes.
How often do you come across a murder case where there's no motive, or very hard to find a motive?
So
Not that it's a crucial element at all, not that it's necessary at all, but is it?
So there's two forms of murder. There's intentional murder, where the accused forms an intent to do it. So usually there's a degree of planning that goes into the murder, or it could be a split-second decision, but they arm themselves or they do something which shows that they thought about it and have decided to go forward with it in a particular way. Then we've got recklessness in terms of reckless murder, which is, you could get a shotgun and you could just fire a spread of it, the bullets. In your head, well, it's a possibility that one of these bullets could hit someone and they could die, but I'm going to do it anyway. So you're reckless as to your acts. So, you know that if they're not going to die, they're going to get seriously injured as well. So you've got that reckless indifference. And so that's the reckless murder.
Does Victoria make that distinction? Is that a New South Wales thing, or do you know where?
Definitely a New South Wales thing, and I think Victoria would make that distinction because it's very much comes from the common law, which we're all sort of bound by here and from England. So, I suspect Victoria would have that.
Okay.
Yeah.
But then she's only charged with three counts of murder, one attempted murder.
Yes.
So does that mean it needed full on intention? It's not reckless, would you say? It's not reckless?
In this one,
Yeah.
in this case, it
Yeah.
was intentional murder.
Intentional murder.
Yeah. And
She
so,
cooked it deliberately, no need for a motive, just deliberately decided to cook it.
well, the motive is what we'd say. I suppose the prosecutor would have said to the jury they could infer from the evidence that you could infer what the motive was, and that was to kill these people. From when she gathered the mushrooms to the way she prepared it, to how it was given to only those guests, which either died or got sick, but yet members of her own family and herself were perfectly fine. So that would show.
Yeah. What do you think of the defense's case? Would you say that this was a very hard case to prosecute? I mean, not prosecute, to defend? Or would you say it's
Oh, look.
there are angles you could approach?
There's two schools of thought. One of them, as a defence lawyer, you could say, well, look, the cards were stacked against her. She should have entered pleas of guilty to get a more favourable sentence. Show some contrition, it happened, but that, of course, is in accordance with your instructions, But the defence case in Erin Patterson's case was that the Crown has to prove a motive, or at least has to give the jury some sort of motive as to, why did she do it?
Yeah.
If she did kill them, why? What was the reason? Did she want money? Did she, was it a vendetta? Was it an axe to grind? Something like that. And there was an absence of that. So the defence said, well, if you're going to, convict this woman of killing these people, then you've got to be satisfied that she had a reason for actually doing it. Otherwise, it just makes no sense. This is just a mum, a suburban mum. She's, invited them to her house. She's told you she got sick herself, and she was scared that her kids ate it as well. So why would she possibly go ahead and kill them? I mean, it just makes no sense. And they can't point to a motive. So in that case, you'd find her not guilty. Which is understandable of running a case that way. But of course, we don't have the full gambit of what all the evidence was. But yeah,
Would you have approached that case differently if you were like the defense lawyer?
well, it all depends upon her instructions. There are some things I would have done differently, but ultimately, if that was the defense of lack of motive, then there was really nothing more the defense lawyers could have done apart from run the case the way they did. And that probably explains why their closing was so much shorter, because they focused on that aspect. And there are cases that have been won, on focusing on a narrow point, because it is for the prosecution to prove the guilt of someone.
So it took the juries, I think, 7 days. Well, actually, no, I don't know if 7 days, maybe 5 days.
Yeah.
Maybe like under a week, somewhere between 5 to 7 days to come to a conclusion, come to the verdict.
Yeah.
Is that a long time? Is that considered a long time, or is that short? Or is that considered short, given like the severity and how long the case went? Is there any like
Hard and fast rule?
Yeah, not no rule. I mean, like, do you reckon like the jury knew from the very beginning when they went back to deliberate? It's like, yep, she's guilty, but let's go through things one more time and see whether we're changing it. Or was it more like, we really don't know. Let's re-examine everything and come to a conclusion.
Look, 5 days, I think, it was a reasonable time for the jury in a case like this, with the amount of evidence that was proffered. Juries are a funny thing. Sometimes you can have a 2-day trial and they can take 7 days to come to a decision. Other times you can have a 6-month trial and they take half an hour to come to a decision. So it really depends on what happens in the case. And in this case, considering what the evidence was, I think the jury did their job quite well by taking the time to go through all the evidence before convicting. You've got to think, if they had their mind made up quite early on, they wouldn't have waited 5 days. They're allowed to come back at any time with a verdict. But what they did was they came back with a unanimous verdict, which could also mean that there could have been a couple of holdouts that they were trying to convince within the jury. All right, so it is possible, okay, that that could have been the reason why, and they had to go through it all again. But
Interesting.
yeah.
So now with what's happening now, where Erin is appealing, what can you tell us? What might happen? What's going on?
Well, she'll appeal to, and I assume the Victoria's Court of Criminal Appeal, or the New South Wales equivalent down there, and she basically would be appealing on an unreasonable verdict,
Unreasonable.
or something that happened in relation in the trial that could be revolving around a piece of evidence. So perhaps the evidence shouldn't have been tendered, or perhaps the jury saw something that they shouldn't have because it was too prejudicial. So we have prejudicial versus probative value in relation to a piece of evidence. And if it's too prejudicial, and that the jury can't be cured in terms of, well, they can't put the prejudice aside to actually look at it independently, then perhaps it resulted in an unfair trial.
And if that's
the case, it can be ordered to be a retrial. She could be acquitted. There are things that happen.
A retrial, like potentially another 10 weeks.
Yes. Yeah. So it can happen. It does happen in New South Wales. I suspect Victoria would be the same.
In a retrial, could they then downgrade the charges from murder to, like, say, manslaughter?
No.
So
They can lay ex officio for alternative charges based on the same evidence, but really, the Crown can't change its case. Okay, but can I say this, in terms of a murder charge, manslaughter is always available as an alternative.
So you're saying that, let's say she won on appeal and it has to go for a retrial, the prosecution can just come back and say, all right, we're going to change up a little bit, we're going to go for manslaughter now.
No. So the prosecution has their case. If they're going for murder, they're going for murder. But the judge can direct them. And mind you, this might be New South Wales only, that if they're not satisfied on the charge of murder, they can find the accused guilty of manslaughter, meaning that they didn't mean to kill them, but their acts did cause the death upon, that sort of thing. Yeah.
All right. Okay. So, all right, let's assume that, assuming she hasn't been sentenced yet and she's going for it, what happens in a sentencing hearing? Sentencing hearing, is that what you call it?
Yeah, sentencing hearing. So in there, the judge will find facts from the jury's verdict. So what happened in the trial, and usually both parties come up with a set of agreed facts that the judge can go off, but sometimes it doesn't happen, so the judge will make findings. And then
As in the judge will find what the jury took into account to come to the verdict.
Exactly.
So the jury has to explain why they came.
No, the judge will make those findings based on the evidence as it fell.
Okay.
So the jury's obviously accepted that this happened, and that in terms of what she did, and I suspect in this case, the evidence is quite strong independently, and when they were pieced it together, it would show that there was a consciousness of guilt on her part, and what that means is she recognised she was guilty, and she tried to get away with it by concocting a story to make the evidence fit.
Would you say that would be like an aggravating factor?
Well, it goes to contrition and remorse, which are things that we take into account at sentence, whether someone's sorry for what they've done, and whether they can be going to rehabilitation and things like that. And in this case, Erin will protest her innocence if she's appealing, and so that value is going to be nil, if anything, because she doesn't accept that she's guilty.
Got it. So there's no contrition,
No remorse. And so, that won't be taken into account. The other aspect of it is, at a sentencing hearing, the offender puts forward their subjective case as well. So that the judge finds the facts, puts what they call objective seriousness in terms of where they place the offending conduct.
Is that the mitigating aggravating factor now?
No. So that's objective seriousness is where they put where the case falls on the scale of whether it's really serious to less serious for that type of crime. All right, and how it got carried out. In this case, and then the defence will put forward their subjective case, which will be, things that are home to Erin, such as she's a mum to a number of kids, whether, what her life was like, whether there were any issues, whether there were any psychological issues, things like that. So all those things that are subjective to the offender get put before the court. And the idea behind that, from a defence perspective, is to try and say, well, my client isn't the vehicle for general deterrence, you should treat her differently, or she's more warranted to a less harsh penalty than what you would normally impose.
So this is where it's our argument on it's not about whether she's guilty or not, it's more like how badly should she be punished.
Yes, yeah. And so that's what a subjective factors go to, and obviously to mitigate the sentence that would be imposed.
What's your gut feel on
My gut feel, she's going to get life sentences, I think.
Is life actually life here?
For 25 years, and they'll just get added on, so she won't. I don't know. Victoria's a bit more tough with their sentencing, I think, compared to New South Wales.
So that means
they're
life
more prescriptive.
Life means life.
Yeah. Here, it depends. We've introduced things such as no body, no parole type of laws and things like that. So
what does that mean?
What
does no body, no parole?
So in terms of people who have killed someone and then done away with the body, you can't find the body, and then they won't disclose what they've done with it. So
no
in
parole,
that case, you'll go to jail, and you've got no chance of going on parole. So
What's parole?
Parole. So you still serve a sentence, but you get to be discharged back in the community, subject to conditions, almost like a good behaviour bond.
So you're serving the sentence while back in the community.
Yeah, and if you breach that, you go back into custody and serve the remainder of the sentence.
So in this case here, she'll most likely get life sentence, and it could mean that she'll be in there for the rest of her life.
Yes.
No parole. Any parole? Any chance of parole? Not really.
Again, you'll have to look at Victoria for their specific sentencing aspects.
Let's say if it was in New South Wales. If it happened in New South Wales, what are we looking at? Would there be parole? Maybe.
There could be. I've seen it happen.
Yeah.
There are some cases where there's no parole, but most of the time, and especially in her case, I suppose, because she's got no criminal history, I assume, or anything that's relevant, it is possible she could get parole, but a long time. She hasn't served. I think she served the period from when she was charged to trial in custody, and that's
2 years already?
Yeah, that'll get taken off a sentence. But you've got to think about the sentences that have come before, and that's how they'll work off. So that here she's killed multiple people, albeit the same event. And as I said, the degree there is a degree of planning that's gone into it. So all that aggravates the sentence. Makes it higher. So
I think you're getting thirsty.
Huh?
Cheers,
Does
cheers,
it make
cheers.
sense what I'm saying?
Let's ask the public. Does he make sense?